up there that references that Matador's acreage is awaiting assignment from the state land office. Do you see what I'm referring to?
Yes, sir.
Can you provide me a little bit more details as to the current status of the acreage?
Yes, sir. So the interest is owned by Matador. This was involved in our Emeritive acquisition, and so the record title ownership is pending with the state land office to convert it to from Emeritive New Mexico into MRC Toro LLC, which is the surviving entity of Emeritive New Mexico.
Okay, so would it be accurate to say that ownership has already transferred and you're simply waiting final approval from the state land office?
Correct. Yes, sir.
Okay, thank you. Can I draw your attention to, well, pretty much anywhere that the legal description is mentioned for the unit? The CPAC may be the easiest. Should be towards the beginning of the application packet. Or do you know what I'm referring to by when I say CPAC?
Yes, sir. I believe are you referring to my self-affirmed statement right before the exhibits C1 through C?
Um, I'm not, but we can go to your self-affirmed statement. That should have the legal description for the unit in it as well.
Yes, sir.
Okay, looking at that legal description, towards the end, you see where it has the equivalent um, acreage provided there.
Yes, sir. Describing section 35 being a regular section.
No, sir. I don't have it directly in front of me, but there should be reference to the governmental equivalent. I believe in one case it says like the west half of the northwest quarter, and the other case, I think it says the east half of the northeast quarter, something
Yes,
along
sir.
those lines.
Yes, sir.
Okay, in the case you're looking at, is that equivalent correct?
Yes, sir. Oh, uh, I'm looking at. Okay, yeah, that looks incorrect for describing lot 3.
Now, the
Okay,
rest of the legal description, is it correct other than the equivalent?
correct. Yes, sir. It explains the northeast of the northwest, which would be correct. Yes, sir.
But it is accurate that the equivalent is incorrect. Is that also correct?
Yes, sir.
Okay, can you check your other case to confirm whether that one is correct or not?
Yes, sir. So that one is also incorrect on the equivalent, and we can get that corrected.
Okay, is it correct that the same discrepancy made its way throughout the entirety of this application, including the original application provided at notice and the public notice?
Let me see. I believe that is the only mistake.
The equivalent is the only mistake, but
Correct.
is that mistake included in the original application that was provided to each of the interest owners?
Um, are you referencing the initial proposal?
I'm referencing the application that was mailed out in the written notice of this case.
Okay, let me scroll down to that.
Ms. Vance may be able to provide you with a page number if that helps.
Okay, I do see it. Yeah, in the application, the equivalent is incorrect, but the description outside of that is correct.
Okay, thank you, Mr. Carsley. Thank you, Mr. Hearing Examiner. I don't have any more questions for these cases, but we do need to make a determination in regards to notice for these cases.
Okay. Do you have any suggestions, Mr. McClure?
Well, the legal description is extraordinarily important in these cases. So ideally, we'd probably reconduct notice.
Okay, Ms. Vance?
So it looks to me like it's just case 25582. Is that correct?
Mr. McClure?
That's incorrect. That's incorrect, Miss Vance. It's in both of these cases.
Okay,
At least
yeah.
it appears to
No,
me, but,
I see. I see. Well, what I would say is that is that's just a scrivener's error. That equivalent, it's just just there to provide for, a little additional description, but what is included is the correct legal description. At this point, all of the notice was received by these parties, and we haven't had any protest, and we haven't had any parties reach out for further clarification. And those parties did receive their notice, and if they had a question, they could have reached out just for clarification. So I would argue that it's just a scrivener's error, and these parties received notification, and if there was confusion over that equivalent piece, that they have all of the contact information and had the notice information available to attend the hearing.
Who drafts the legal description?
We do in our
Oh,
office, and
you
then
do.
we confer with our client. So
Okay.
that was just, again, a scrivener's error.
Oh, okay. I heard your argument. So you guys drafted, and why do you put in parentheses the equivalent? What's the purpose of that?
Because sometimes, you may be sending out notice to an interest owner who's not maybe familiar with lots. And so it just provides, and sometimes the lots are oriented differently depending on the section. So you might have 1 through 4 as your A through D, and then in a different location, you might have that 1 through 4 along your west half. So it just provides further clarification. But again, based on the GIS that you look at from, on the division's portal, you could go and you could read that legal description and see that lot 3, is here on the GIS map.
And so what about the equivalent is wrong?
So in this case, in these, it should state for case 25581,
Mm-hmm.
it should be the east half of the northwest quarter equivalent.
Mm-hmm.
And then for case 25582, it should be the west half of the northeast quarter equivalent.
And what do they currently say?
So in case 25582, it has the east half of the northeast quarter. So again, it should be west half. And then in case 25581, it has the west half of the northwest quarter, and it should be the east half of the northwest quarter.
Okay, I understand the problem here. When it comes to notice, the division is particularly careful about making sure that notice is extremely accurate. And In the past, we have required renoticing of cases in which the notice has not been exactly 100%. What would it take to renotice these two cases?
We would immediately send out the notice with a correction. I think we would need to file an amended application and then just send out that notice.
Okay.
And then possibly come back on the 9:30 docket.
On the 30th.
On the 30th,
Right.
yes. Because I think I'm not sure if that leaves
How
us.
many days? You need 20 days, don't you?
Yeah, we should be good.
And it seems like it's 1 day too short by my calculations, but I could be wrong.
You're correct.
Okay, so then maybe October 9 then.
Might be October 9.
All right. All right, well, yeah, so for the future, Ms. Vance, and for anyone who's listening, notice has to be 100% accurate. If it's not, we're gonna have a problem with it. And if I'm not mistaken, then we have case number 80 that's coming back on the 30th that we can deal with on the 30th. 81 and 82 will be renoticed with an amended application to correct the error, and we'll have that on October 9. We'll put them at the beginning of the October 9 docket.
That works perfect.
Sorry, Ms. Vance. Anything else?
No.
Okay.
No, I tried my best.
I know. Well, it was a good argument. Okay, so we're off the record in those cases. Thank you, Ms. Vance. Now we're going to go to our last cases here. This is Rockwood Energy versus Coterra Energy. It was a contested hearing. We're back on because we required a bunch of additional information and corrections, not necessarily from both parties, but corrections from both parties. Anyway, so entries of appearance, please.
Good morning, Mr. Examiner, Dina Bennett, on behalf of Coterra Energy operating in all of the cases.
Thank you.
And good morning, Mr. Hearing Examiner, Caitlin Locke for Rockwood Energy LP in all of the cases.
Thank you. And I'll just call the case number since I think it's proper. 252-43-44-45-46, 255-20, 21, 22, and 23. Okay. Were there any other parties that I don't think there are, but are there any other parties that you know about?
Mr. Examiner, Mr. Bruce entered an appearance in these cases on behalf of Marshall and Winston.
Thank you. Mr. Bruce? Okay. Maybe we'll hear from Mr. Bruce later. So at this point, all of the exhibits have been reviewed. And I believe we're going to take these cases under advisement at this point. Now, I know the parties are interested in a closing argument. Is that correct?
That's correct. Well, I believe Ms. Luck may have requested a closing argument at the last hearing. And I also believe that the division sent us an email saying that a closing argument would be due in 2 weeks from today's date. But I would like to ask the divisions, like some discretion to have the closing argument be due sometime later than that, because the parties are in discussion still, which could alleviate the need for the post-hearing brief. So I would request that the post-hearing briefs be due in a month from today, say, instead of 2 weeks from today.
Okay, Ms. Luck?
And yes, Mr. Hearing Examiner, I'm in agreement with Ms. Bennett and Coterra's position. Rockwood is just waiting on a final agreement from Coterra and would like to resolve this outside the OCD if possible. So an extension on the closing would be appropriate if allowed by the hearing examiners.
Okay. I don't see any reason why we should rush the parties into closing arguments. I mean, the record is closed at this point. We're not taking any new evidence from here on in. A closing argument is not evidence. It just may be helpful to Mr. Fordyce to draft an order if needed. If the parties do work out a deal, Ms. Bennett, would Rockwood dismiss his cases?
That's my understanding.
That's what I thought. Okay. All right. And And then would your cases proceed, would the Coterra cases continue or would they not continue?
They would continue, and once, if Rockwood withdraws its competing applications and withdraws its objection, then Coterra would notify the division and ask that the division treat the cases as affidavit cases and put them into the normal queue for decision.
Okay, okay. I'm not sure about that, treating it as an affidavit case, but I understand that they wouldn't be protested at that point. And so the evidence that we already have in the record would satisfy the cases moving forward at this point. Okay, when do the party, okay, so let's set the date. Let's set the date for the closing arguments. So you said a month from today, both parties have agreed to that. Today is the 11th. We'll say October 11 will be the deadline. There will be a 10-page limit on closing arguments. Anything over 10 pages will not be read. So I'm just letting everyone know now. That includes your very first page. So it's not just, you know, where you decide to start. 10 pages is 10 pages. And let's see, when would we hear? Yes?
Mr. Hearing Examiner, October 11th is actually a Saturday. I was thinking October 9th.
That's fine.
Okay.
October 9 is fine. Which is a Thursday.
Yeah. I
Okay,
mean, I
very
guess Monday the 13th would be okay too, although that looks like it might be a holiday. So we're just running into some challenges there. But I think October 9th, that has what I was thinking is October 9th.
Okay, that's the deadline, is October 9, 10-page limit, closing argument. No new evidence will be considered. No new evidence should be argued in the closing argument. If the parties settle this case, which it looks like they're going to, how will the division hear about this?
Well, Miss Luck would, and you can feel free to correct me, Caitlin, if I'm putting words in your mouth, but I believe Miss Luck would file dismissals of of Rockwood's competing applications and would withdraw the objection to the Coterra cases, and then
Okay.
I would follow up with an email after that.
Okay, that sounds good to me. Ms. Luck, if you do file a dismissal, please state the reason clearly why you're dismissing your cases.
Okay, well, thank you.
Okay. So I'm trying to think if negotiations drag out further. I mean, I don't know what's involved in these negotiations, but it could be anticipated that negotiations would go further than October 11. So what would happen in that case?
Well, I did consider asking the division to set these cases for a status conference so that we could come before the division and report on the status of the discussions. But I also want to be respectful of the division's docket and the division's time. But that was one potential path forward, is instead of having our briefs due maybe on October 9, have us come in and report on the status of the discussions on October 9th. I'm not sure how that resonates with you or with Miss Luck, but that was an idea I had this morning.
Ms. Luck?
Oh, I don't have any objection to that plan. I think that this is all assuming that an agreement is reached, and then Coterra would move forward with the presentation of their cases. So that's fine.
Ms. Luck, how close is there to resolution?
It's my understanding that the parties are almost done with a deal. They're very close to the deal, but it's my understanding Rockwood's just waiting on Coterra to provide the documentation for Rockwood to sign and finalize.
Ms. Bennett?
I'm not entirely sure about that level of detail. I know that they are working on a deal and I know that they've reached an agreement in principle, but I'm not sure how close they are on actually finalizing it.
Okay. Well, these cases have been around since February, so I'm not amenable to setting it for another status conference. So that closing argument deadline is a deadline. In effect, we're giving an extra 2 weeks to the division after spending a bunch of resources hearing these cases. We've given, I think, enough time to resolve these between the parties. So if an agreement is not reached, then closing arguments are due on the 11th, and the division is going to issue an order based on the evidence that we have. So that's, I guess, a pretty hard deadline for the parties to settle their negotiations.
That sounds good. And just to be clear again, it's the October 9th is the
Correct.
deadline.
I'm
Okay.
sorry. I said October 11. I meant October 9. Thank you. Anything else, Ms. Luck?
No, thank you.
Very good. Ms. Bennett?
Nothing else. Thank you so much.
Very good. Hope you feel better. Thank you.
Thank you.
We're off the record.